how to avoid costly payroll mistakes. My name is Julie Dorr, and I will be your moderator for today's event. Our presentation will last approximately 40 minutes, and we'll have the remaining 40 minutes, well, the presentation will be 40 minutes, but the remaining 20 minutes or so will be for your questions. Feel free at any time to type in your question over on the right-hand side. We'll put it in a queue, and we'll reserve all those and answer them in the order that we received them at the end of the presentation. Earlier this morning, I did email you a link to a copy of the presentation that's being used for our webinar today. If you haven't received it, feel free to email me right now. There's my email address, julie@enlightenedbiz.com, and I'll be happy to send that to you. Hopefully you'll get it in time to take notes during the presentation. Before we get started, please note that this webinar and all of the accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with your legal counsel to address any of your specific situation. Well, we have got a fantastic panel today. We got 3 people, and I'm going to start first with Linda Duffy. She's the president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, leadership talent development, and also increases organizational effectiveness. Next, we have attorney Marla Mehrab Robinson. Marla is with the law firm Mehrab Robinson, Jackson, and Clarkson, where she is a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. And then also we have a guest speaker today. Her name is Debbie Biscotti of Ovation Payroll Services. Debbie is the district sales manager with over 22 years of experience helping her clients find the best payroll solution. So Linda, you're going to start us off today, so I'm going to turn everything over to you to get going on that agenda.
Thanks, Julie. And welcome, everybody. We're so happy to have you with us today. And a special thanks to Debbie Biscotti, who is our featured guest speaker today. You guys will be really excited to hear what Debbie has to say because she's out there in the trenches and sees payroll mistakes all day, every day. One of the things that's great about Debbie is she believes she's out saving the world one payroll at a time. So hopefully she'll be able to give you some insight into how you can fix some of these issues that I have up on the agenda here today. I'm not going to bother reading them all off because you guys can read, and we're just going to jump right into it. One of the things that was interesting that Debbie shared with us is that statistics show that 50% of companies that do payroll in-house end up getting some sort of penalty from the IRS or EDD for some of the reasons that she's going to talk about. So I know I, for one, when I started my business, would never undertake doing payroll for my own business. So even as a small business with just a couple of people working with me, first thing I did was went out and got a payroll service. So just something to keep in mind. And with that, I'm going to turn it over to Debbie so she can jump in, and then Marla is going to talk on a few different topics, and then we'll come back around to me to finish up. Debbie, it's all yours.
Thank you, Linda. Yes, 22 years, believe me, I have met with many, many people. I've converted over 4,500 clients, so I have seen every type of problem that they have had, either with starting payroll themselves, trying to do it in-house, or maybe even getting with a service that didn't do what they said they would do. And so today what I'd like to do is just go over some of the biggest things that I see on a day-to-day basis that might help you. One of the things I see is wages sometimes are reported in the wrong quarter. A lot of businesses think that when the payroll is accrued, that is the quarter that those wages should be reported in. And an example would be, let's say the pay period was 9/15 to 9/30, but then the check date was, let's say, that following Monday or the 3rd of October. Well, that started a new quarter and should have been reported in quarter 4. However, many clients I meet with have put it into the incorrect quarter and possibly the wrong year, especially if the employee works, again, maybe the 15th to the last day of December. The check date goes into January. They report those wages and put on the W-2 for 2013. What happens then is that the quarter W-4 would have to be amended, and all the W-2s and all the year-end, and that can be very costly for someone doing it possibly in-house and having the CPA do after-the-fact payroll. They would have to go in, amend all those returns. So that's just something important to remember. It's the check date that establishes the month and quarter that that payroll should be reported the taxes in. The fines can be up to 10% as well, so that can be quite hefty if you're running a large payroll. Another big thing I see is paying the taxes late. I meet with clients that go, oh yeah, we pay every quarter, we pay our taxes. And I say, oh really, so tell me about that. And they said, oh, we've been doing it 10 years and that's, you know, the way we do it. However, maybe they haven't been caught yet because it takes time for the IRS to get to everyone. But the really rule of thumb is everyone has 2 different schedules that they must pay their taxes for their payroll on. And that is the 15th of the month or 3 banking days after the check date. Now, how this is established is it's called the look-back period, but basically when a company pays $50,000 in federal employer and employee taxes, that would be your Social Security Medicare employer, that would be your federal personal PIP withholding from the employees, and any FUTA. If that adds up in 4 quarters to over $50,000 as a company grows, then they're mandated to pay their taxes and remit them so they arrive to the IRS, and the EDD follows the same rule, 3 banking days after the check date. So again, penalties for not paying these timely can be up to 10% or even higher. So to avoid those penalties, you really need to understand that you're going to need to pay the 15th of the following month, following the month of payroll, or 3 banking days, depending on your federal liability. And then the next area is S-Corps. Boy, there's a lot of little S-Corps, a lot of people that have maybe been laid off or started new companies, and they're excited to open their corporations, and sometimes they're very profitable very quickly. And I find a lot of the one-man corporations don't want to pay their taxes till the end of a quarter or the end of the year. However, when you are a owner of your own corporation and you are profitable, the IRS has hired many, many new agents to go out. It's an easy audit to look at the bank statements and to see if you were truly profitable throughout the year and just paid maybe in December at the end of the year. They can go back each month you were profitable and assess a 10% penalty. So that's another area where I try to teach the S-Corps, again, if they're profitable, they should pay a reasonable compensation to themselves at least once a month. And that's what we usually do. It's just on a monthly basis. And then maybe in December do a larger amount according to what their CPA would like them to do. So that's another area where I see a lot of penalties. Training wages. So employees are salaried exempt based on the work they perform. However, if you hired someone on a salary basis, and this happened to a company I know very well, and they were actually sued, and the employees on a class action suit were hired as a salary-based employee. However, they were in training for 3 to 4 weeks, sometimes 6 weeks. And with that, they worked a lot of overtime and long hours learning and going out in the field and following other sales reps to learn their new trade. However, the employees in a sales training environment need to be paid hourly, not on a salary basis, until they are done and finished with their training. So the company ended up paying a lot of money, millions, out to all of these fellowship of this very large company because they just worked them to death on a salary while they were training. So that's something that you need to remember is when you're training, to make sure that you are tracking their hours, that it's not over the 8 hours per day in the state of California, which would establish the overtime. Then you need to pay the overtime. Okay. Incorrect or unverified Social Security numbers. Employers may not report taxes under a Social Security that they know is false. There is a new I-9 that came out in May as well, and you are supposed to be able to view, as an employer, those Social Security numbers on some type of documentation, which is usually the Social Security card. We also provide a verification for our clients so that they know that this is a incorrect and does not match Social Security number. Some employers we find say, I don't have that number yet, she hasn't come in, I'm going to get it and give it to you next week. However, if they file, or a company or in-house files a W-2 without a Social Security number, they are fined $50 per employee. And something we do at Ovation is send emails and reminders that that Social Security number still is not matching and that year end is coming up and we do need that Social Security number or you will be fined. So we remind our clients so they know they do need to get this information to stay in compliance and provide the correct Social Security numbers from their employees. Okay, bonuses. We all love them. However, I know when I get them, I'm kind of sad when I see them because I'm like, wow, was it 50%? So something important to remember, and I have a lot of clients that have salary plus commission or bonuses that they want to run, and they ask, should I run a separate check because it puts them in a different tax bracket. Let's say an employee makes $5,000 on their salary, that they have a $10,000 bonus. What that's going to do is now show the gross payroll at $15,000. The software through the IRS will now show that that is $15,000 times 12 months, which puts you in a much higher tax bracket, and then they're taxed on that higher limit. So what most companies do is write a separate check. They can run it on the same payroll run, but just do a second check, and then they can tax it differently. Now, the law for the IRS is 25% for federal withholding. If it's $1 million bonus, which I haven't seen one of those in my 22 years, but it's 35%. EDD for state of California, for the state EDD withholding for that employee is 10.23%. So again, this is a separate check, different than their normal salary or hourly check. This is the way that it's mandated. There is another rule, but I would have to send you the website to do that calculation. If you want to put it together, you must add up the salary plus the bonus, subtract out what the taxes would have been. It's a whole little calculation formula. So anyone interested in that, I can send you the website that gives you that formula that can help you to do that. But another big mistake I see is clients say, well, yeah, when we bonus, we 1099 those bonus checks. And that, again, is a big no-no. Any compensation is compensation that has to be taxed. So bonuses, commissions, I've seen people try to put them completely on 1099s, and they have a W-2 1099. Big flag, huge flag for the IRS and EDD. They just jump right in. You cannot do that. So that's very, very important to make sure that any type of auto allowance, any of these type of compensations, they are all subject to be taxed.
Debbie, thank you so much. I will tell you, like Linda, as a small business owner, from the day I opened my doors with only 2 employees, I knew that the #1 way to avoid payroll mistakes was to use a service. So a lot of this information I didn't know because I've always relied on the service to do that. I think the second way to avoid payroll mistakes is to know where the employer makes mistakes that aren't really having to do with the calculations or payments of payroll, but some of the laws regarding what happens beforehand. The first is misclassifying an employee as an exempt employee. We've done a previous webinar on this, so I'm not going to spend a lot of time the site is there for you to see, but just very briefly, when you misclassify an employee as salaried, exempt, and in order to avoid paying overtime, that can become a major payroll mistake, obviously, if it's wrong. And the most common mistake in this area is that employers believe that if you pay a salary 2 times minimum wage, that makes you exempt. And the good news is most employees believe that as well, but it's just not correct. Very briefly, and you can get the details at the seminar slides, is you have to fall into one of 3 categories. You have to either be a professional, which means you have a license as a doctor, lawyer, teacher, engineer, or you have to be a manager/executive managing 2 or more people 51% or more of the time, and managing means you have the authority to promote, demote, hire, and fire, or at least that your opinion counts in that decision making. And the third and more difficult exemption is administrative, where you are not working on what the products or services of the company are, but you're working on the business of the business. A lot of cases up with it, 2 or 3 cases up with the California Supreme Court right now to help us better define that administration exemption. It's a very difficult one. A second area we see mistakes is misclassifying employees as independent contractors. Many employers and employees / independent contractors believe that the parties can define their relationship. Let's just have a contract that says I'm an independent contractor. I don't want taxes taken out. I want to be paid on a 1099. I can take care of those things myself. It's not your choice, either one of you, as an employer or an employee or an independent contractor. Who decides the classification is the IRS, the EDD, the DLSE, or the court. So your decision doesn't count. So I would encourage you in this area to seek the help of a human resource consultant like Linda or an attorney like me, and if you're not sure, because this is an area where the penalties are huge. And like Debbie said earlier with the S Corporation audit, this is an area where the IRS has engaged more people to come out and audit because it results in a lot of money to them. And more often than not, the employer is wrong. Again, we did a previous slide on that, or webinar on this, and the slides can be found at the site listed. The third common mistake is meal period violations. Once again, we did a very lengthy webinar on this, and I would encourage you to look at the slides on that at this site. But remember that this goes to timekeeping as well, that non-exempt employees must clock in and out for meal periods. And their meal periods must start before the beginning of their 5th hour of work, and we have an example there. Rest periods, on the other hand, do not need to be accounted for on time records. Following that is, again, tracking time, not requiring employees to track time. Exempt employees are not required to track time. Non-exempt employees are required to track time. The difficulty here is many employers often, as I said earlier, misclassify someone as exempt who is truly non-exempt. And the problem is when you show up at a hearing at the DLSE or in court, and the commissioner or the judge says, where are your time records? Because Mr. Employer, by law, you are the one required to keep the time records. The employer says, well, I don't have them because I thought they were exempt. The employee then produces records which under the law are deemed to be absolutely true because the employer failed to keep records that it was supposed to keep. You are allowed to try and defend against those records, and we can sometimes do it with cameras to show that somebody who claims they were there weren't there, computers, but it's very difficult. So some attorneys and consultants will advise you to require exempt employees to keep records as well, just in case they're misclassified. That will not change their status, so there is some protection there, and that's good news. It can become offensive to some high-level executives who truly believe they're exempt, and so sometimes we'll split up who we know is truly exempt with those who are maybe more difficult to define because the law is not clear on some of this. For example, the administration right now is very unclear. So we might require those people to keep records in case it ever comes up. There's also issues regarding rounding. You're allowed to round to the nearest 5 minutes or the nearest 1/10, which is 6 minutes, or 1/4 of an hour, so long as the practice averages out over a period of time. It must not result in a failure to compensate the employee for time actually worked. So very risky if you're rounding more than I think, the 5 or 6 minutes. Also, errors in time punches. It's the employer's obligation to keep accurate time records, not the employees. So if employees are inaccurately punching, you need to get back to them right away. And I say punching, it could be recording. There are many different methods of timekeeping. Not one is required. It can be fingerprinting these days. It can be turning on a computer. It can be sight recognition, handwritten time records, time clocks. They all are acceptable means of time record keeping. But the accuracy is the employer's obligation, not the employee's obligation. So it's very important that if you see errors that you get to the employee right away, get a statement from them that it's an error, have them sign off on it. If the burden of proof is always going to be on the employer. The other flip side of errors and time punches is employees who punch in early but then don't go to work. Same thing, you need to get that corrected right away. And finally, from me, unauthorized deductions. Generally, you cannot make deductions from an employee's paycheck unless required by law or expressly authorized in writing by the employee. And the types of the deductions that are allowed are, to cover insurance, hospital, and medical dues. Your premiums through insurance policies. Other benefits that the employer might offer, for example, a 401k program. You are not allowed to deduct for the employee's breakage of items, especially if it's covered by negligent. If they were just negligent, they didn't know what they were doing. If you can show a dishonest act or gross negligence, and I would tell you that this is a very high burden. Basically, you have to prove that the employee intended to harm the employer, what used to be the same burden of proof as in unemployment insurance. Stealing, if you can prove that an employee stole, then you can deduct, but otherwise you can't. There is a strong public policy against deductions. So I would encourage you not to deduct anything unless you are absolutely sure that the deduction is allowed, because the penalties are huge. Many of you are familiar with them. For every day that you didn't get your wage, you're entitled to a day's wage up to 30 days. And not just the amount that they deducted, a day's wage up to the 30 days. And there may be penalties and interest on top of that. That may be discretionary, but that's mandatory. It cannot be removed by a judge or administrator in the DLSE. So because those penalties are so huge, you shouldn't make those deductions. Now, one area where you can make deductions is with tools and uniforms and computers and keys and things like that. If you have an employee sign when those items are given to him or her, a receipt of company property form that specifically identifies the property and the value of the property and states if you fail to return this on termination of employment for any reason, this amount will be deducted from your pay. That is allowed. What is not allowed is at the end of employment to deduct other amounts that the employee might have previously authorized for loans and advances. There's a case, if any of you are of the kind that like sites and cases, I always throw a couple out there during our webinars, called Barnhill, which is a seminal case in this area. And if you have an employee, which we often do, who says, I need to borrow a couple $100 in advance of payroll, or a couple $1,000, and can you spread it out? Can I pay it over a couple months? They sign a note, and you can deduct, and in the note it says you can deduct from each pay period a certain amount. That is allowed. What's not allowed is if the employee terminates for any reason before that amount has been paid off, you cannot accelerate it and say, okay, it's all due now. Even if the employee signs saying it's okay to do that, you cannot do it. And the courts have said the reason for that is you cannot get ahead as the employer of all the other creditors because you have control over that money. Now, if you have the employee sign again the day of termination that says, yes, I want you to take it right now, the day of separation, then it would be okay. But be sure you're not using unlawful tactics to get them to do that. And with that, I am going to turn it over. Oh, before I do, Linda, before I turn it over to you, let me just say that the penalties on that also are very huge. There's no small penalties in the wage and hour game. So, Linda, I'm going to turn it over to you now for some more common mistakes.
Thanks, Marla. That was great. Okay, so the first one I want to talk about is actually a little bit of good news. A lot of times, as Marla mentioned, our clients will say, well, I put them on salary because I don't want to pay overtime. And unfortunately, that just doesn't work. So one of the ways, though, one of the things I think that the California legislature did well as they realize finally, real life, people have personal obligations. So someone comes in and says, you know what, I need to leave 2 hours early on Tuesday because I have a doctor's appointment, but I'm going to make it up on Thursday. And the good news is that if you follow the rules regarding makeup time, you do not have to pay that overtime on Thursday. Now, there are certain rules involved in this, so if you don't have a makeup time policy right now, feel free to reach out to me or Marla and we'll help you with that. But the hours that are involved must be in the same work week. So you wouldn't be able to say, I'm going to leave early today, so I'll make it up in 2 weeks or something like that. And the makeup time cannot exceed 11 hours in a day or 40 hours in a work week because then you still will have an overtime obligation. The other thing is this has to be regarding a personal obligation of the employee. This is not for the employer's use. It's not for me to say, oh, you know what, I don't really have a lot of work for you today, so why don't you go home, but I'm going to have a lot more work for you on Thursday, so I'd like you to work 10 hours. That is not legal. But if an employee comes to you and says, hey, is it possible for me to do this, then you should have a form for them to sign that you can keep with their payroll records to substantiate why you didn't pay them the overtime on Thursday. The other thing that's very specific in the law says the employer may not encourage or solicit an employee to use the makeup time. Okay, so it has to be their idea. You certainly, as I do when I write handbooks for my clients, I'm sure Marla does as well, put it in there as part of the policy that the employee should come to us if they want to take advantage of that policy, but you cannot go out and encourage people to use it. Another thing that we see is not paying people on time. And this seems pretty basic, but the rules are different depending on how often you're paying people. So hopefully no one's violating this. But the first requirement is that you establish a regular payday and post a notice that shows the date, time, and location of payment. So wherever you're putting your regular posters, some of them have a spot where you can write this in. If not, just make it on a piece of paper and tack it up next to the rest of the posters. If they're paid semi-monthly, then the wages earned between the first half of the month have to be paid no later than the 26th. So you can see you have a pretty good 11 days there in which to pay the wages, okay? And then the same thing for the second half of the month. But once you switch and you go to a weekly, biweekly, and a semi-monthly that's on a different schedule, so let's say you go from the 10th through the 25th or something like that, now you have to pay within 7 calendar days at the end of the payroll period. So it's a slightly shorter time. So I don't have clients that usually make a decision on how they want to pay based on that, but it's just something to realize that there's a difference in how much time you have in order to pay people. The one sort of, to me anyway, strange exception is that overtime can actually be paid on the next payday. I don't have very many clients, if any, that do this, but if you want to wait, you have to pay the base wages during that pay period, but you can pay the overtime on the next payday if you're recording it as a correction on the pay stub and there's other information has to be included. So again, I wouldn't encourage that, but it's an option if people need to take advantage of that. People also sometimes forget that they need to pay people immediately at the time of separation. So if the company is terminating somebody's employment, all monies are due and payable at the time of termination. Okay, Marla said there are waiting period penalties, attached with this. So you don't have the option of just not paying people, or hey, I'll pay you next week on your regular payday, or something like that. And that does come up. I know Miriam went to one of our clients last week to do a termination, and we had said, make sure you have the final paycheck ready. She got there, they didn't have it ready. So her instruction to the client was, you either cut the check right now while she's here, or you pay her for tomorrow, and she'll come in and get it then. Because otherwise we were just going to have a problem with this employee the termination was not going well to begin with because she was not excited about leaving the company. If the employee gives at least 72 hours notice, then all monies are due at the time of separation as well. So if somebody comes to you and says, I'm giving you 2 weeks notice, I'm going to leave a week from Friday, you're going to pay them all monies due at that time. But if I walk in, if an employee walks into me and says, you know what, I'm quitting, I'm walking out right now, or I'm leaving tomorrow, or something like that, less than 72 hours notice, then I can actually take up to 72 hours to pay them. So if somebody walks into me right now and says, hey, I'm leaving, I'm out of here, I can say, fine, you can come back and get your paycheck 3 days from now, and that's fine. But just remember about those waiting time penalties. Every once in a while, something will happen that they're are wages in dispute, my advice would be pay the amount not in dispute. So let's say somebody says, no, I worked overtime that day, or I did something that requires you to pay me more money. Pay the amount that you agree with, and then that way it's a little bit easier, and you can show good faith later on if somebody questions it. You can say, look, we had a good faith, honest dispute here, and we did our best to work it out quickly. The other thing is commission is another example of when you can hold the commission portion a little bit, depending on how you define when the wages are earned under commission plans, which have to be in writing, by the way. And if you are unable to calculate the commission, so the rule is basically you need to do it as soon as practically possible. It wouldn't take very long. Most of the time, commission plans are such that you can make those calculations at any moment. And I'm sure Duffy would say any good salesperson knows exactly how much commission they have coming to them at any given time, or else they shouldn't be in sales. All right, incomplete wage statements. Marla and I did a webinar on new laws at the beginning of this year, and this is a couple of things. The next two slides that we talked about is that the California Labor Code section spells out exactly what has to be included on pay stubs, or what they call wage statements. So the list is right here, and it's long. I don't need to read them all off to you, but just, it's pretty specific about what you have to include. And any payroll service is obviously going to have all of these included. I worry about the clients that are trying to do this in-house, cutting a paycheck, but not necessarily including all of this information on the pay stub. So something just to keep in mind, either make a pay stub separately if you're doing it in-house, or even better yet, just let somebody else do it for you. If you are a temporary staffing agency, I don't know how they're actually complying with this law. I'm sort of in awe that somebody can actually do this, but it requires them to actually include information regarding each of their assignments on the pay stub, as well as not just working for the temporary staffing company, but for the employers that they're going to go out and service under that staffing company. And that went into effect July 1st of this year. And then one of the issues that people said on the pre-questionnaire, one of the things that people asked about was mileage, and we weren't sure exactly what you meant by that, so we thought we would talk about what comes up for us every once in a while. I'll have clients call me and say, do I have to tax a car allowance, or can I pay it, through accounts payable? Now, again, I'm not a CPA, and we're not here to give you any sort of accounting advice, but here is my understanding when I've looked into this before, is there's two different types of plans. One's called an accountable plan, and the other one's called a non-accountable plan. And if you just Google those phrases, they will direct you to the appropriate IRS website. So an accountable plan is where somebody's turning in receipts, someone's turning in a mileage log, or at least saying, on this day I drove so many miles on business. Okay? So the IRS website actually says they need to show time, place, use, and business purpose of each car trip. That's an accountable plan, so you have some sort of backup for it. The auto allowance, on the other hand, is just a flat fee. A lot of times we'll see this as an executive perk, or maybe even for a salesperson, we're just going to say, okay, we're going to give you a car allowance of so much per month. If it's done as a non-accountable plan, that is taxable. It's included in wages. Debbie alluded that a little bit earlier. If it's an accountable plan, then it can be paid through accounts payable. So you can turn in an expense report. You can say, here's my receipt for whatever it is you want. You could also have them just give you receipts for gas if that's how you want to handle it. But there has to be some sort of backup for it, is my understanding. Now, remember also, in addition to reimbursing mileage and any type of work-related expense, employers also have to pay travel time under certain circumstances. So if you have non-exempt employees, then you want to make sure that you're in compliance with the travel time rules, in addition to just the mileage reimbursement. And Marla and I did a webinar on travel time sometime last year, and that's a link right there, so you can, again, access those slides. Now, finally, before we get to questions, we wanted to leave as much time as possible. Just wanted to put in a plug for Debbie, because Ovation, and now they were bought by Heartland this year. They've actually expanded their platform and what they can give people. Her stuff is amazing, and so I just want to point this out to people. They have a 2-hour call or email back, or their next payroll is free. So they have a guarantee. This is really putting their money where their mouth is. So you are assigned a dedicated payroll specialist to your account. And if you call or email that person with a question or an issue or something, they will either get back to you within 2 business hours or your next payroll is free. Now, obviously, you have to pay the wages, but any fees associated with that payroll is on them. That's really a pretty amazing guarantee if you ask me. They have web-based real-time payroll software. It's not DOS-based like some national well-known people or companies that everybody knows, and usually the go-to people off the top of people's head when you think payroll. Their software is so much more flexible. Their platform allows you to do so much more. And really, I don't know if Debbie mentioned this before, but the people that developed Ovation were people that came out of Paychecks a number of years ago, and they saw a need for like a better, more flexible platform. And so they took the best of Paychecks, and they came and they built upon that. And I've seen their system and used their system, and it's pretty amazing. The other thing is that payroll records are never purged, so you don't have to keep binders of registers on your desk, payroll people, if you're out there. You know, so many times you walk into a payroll office and there's just binder after binder of the payroll registers. They don't purge them, so they keep them for eternity, and you can just go online and look anything up. Everything's paperless, so that's great also. And then they also have a mobile app, so time and attendance can be done via the mobile phone. For some of my clients that have people out in the field, that's really huge because we don't have a really easy way when people are traveling around to have them clock in and out. And so there is a mobile app that they can use for that. The 2 last things, one is they have date rangeable reports, and I got to say the reports are more user-friendly than any other payroll service I've ever seen, where they can go in and you can just specify, you know, hey, how would you like this, an Excel, a PDF, how do you want the report, and you can put it in. One of my favorite reports that sells a lot of my clients, actually, when Debbie goes in, is there is a very, very easy to make report that shows workers' comp charges line item by person. So it's so hard sometimes for people to do workers' comp reports and when they get audited and things like that, or if you have clients like I do that do job costing and they want to actually keep track in a very specific way about all the costs associated with that job or that employee, it makes it so much easy. And then finally, this is huge for anybody out there that's ever tried to go to another payroll company. They offer a 3-year price lock on new accounts. So you know they're not just lowballing you to get the business. They're usually saving, like they saved, one of my clients just a couple weeks ago went out with one of the large payroll companies, and they went out and were able to save them about $5,000 a year, you know, just doing about biweekly payroll, about $5,000 a year. That's huge to a small employer. And they can lock it in for 3 years. And so that's what's great about it, is you don't have to worry that they lowballed you and that next year you're going to get, you know, a huge increase or something like that. Okay, so that's my pitch for Debbie, and I'm sure she would be happy to talk with anybody offline or answer any questions about their particular service. But we want to open it up, and I'm going to throw it back to Julie for the last 20 minutes so she can field our questions, and we'll be happy to do our best to answer them.
Well, and thank you very much, Linda, Marla, and Debbie. It certainly is helpful to kind of walk through and remind ourselves of some of the payroll pitfalls we can fall into. Or a couple in there, I was kind of like, oh, I got to check on that. Anyway, that does conclude the presentation portion of our webinar today. So now we do want to spend the last 20 minutes or so answering any questions that you have. And again, how you do that is you go over to the questions panel over typically on the right-hand side of your computer screen, type in the question and send it, and I'll read it aloud for our panelists to respond to. So let's start with the first question here from Patty. She's basically, and I'm just going to summarize this, Patty, she's gone from her semi-monthly payroll to a bi-weekly payroll starting this last month in September. And basically she has a salaried employee and is trying to calculate out what the remaining pay would be for the end of the year, and she's got about 6 paydays remaining for the as of 10/4, which is October 4th. Is there a easier way to calculate this kind of stuff, or how would you guys recommend when you make a shift from going semi-monthly payroll to bi-weekly payroll?
Yeah, I think Debbie's probably a great person to answer that question.
Yes, I do have clients that do this quite often, and really it's getting out the calculator and really going through a formula to calculate it individually for that employee. So we will do that for them. It's something that if someone needs help with that, I can help them offline with that, but it's, basically you just have to get out the calculator and see what the biweekly would be versus the semi and do some division, and it's just calculation. So it's something that we could help with on an individual basis.
Okay, good. And again, for all of you listening in, all of the contact information for all three of our speakers today is listed on their bio pages in the presentation. So feel free to contact them separately offline after the webinar today. And then Jana has a question she needs some clarification on. For California, she thought the supplemental tax PTO payout cash award is at 6.6%, and the bonuses are at 10.23%. Can you guys clarify that for her?
That's correct. It's just the bonus is the 10.23. That is correct. It's just the bonus. Supplemental is the 6.23.
Oh, 6.23.
I was just addressing the bonus. Mm-hmm.
Got it. Okay. And Dawn has got a question here about what if an employee is negative on vacation or sick time and is paid and terminated. Can you deduct that time or that salary, I guess, if that person is terminated from, I'm sorry, let me rephrase that. Can you deduct that? You got it?
No, I got your question. I probably could ask this about once every other week. No, as Marla said, you're not going to make any deductions from that final paycheck with the one exception she talks about having to do with equipment and things like that. So unfortunately, no. You really can't do anything about it. That's why I tell my clients, don't advance on vacation unless you really are confident that that person's going to be around, or you're just willing to take that risk. Because it happens at the end of the year for a lot of my clients where they've decided, let's say they're going to shut down between Christmas and New Year's, and they ask people to take their vacation or PTO, but maybe somebody is new, and they don't want to have the employee go without pay, so they offer them the option, something like that. But yeah, really your options are, just to let it go or take them to small claims court if it's the amount that they owe you, which none of my employers ever do. So pretty much just know that you're going to be walking away from that amount.
Okay, good. Okay, and then we were talking about accountable, and Diana has a question. Is the accountable auto plan counted as income for the employee?
Well, I'm not sure what you mean by an accountable auto plan. So if you have, this is my understanding, again, see your CPA, to be absolutely positive, but when I work with clients, a lot of times they'll just say, oh yeah, we give the CEO, a $600 a month auto allowance. He's not expected to do anything in terms of documentation. Okay, that's a non-accountable plan, and so it is taxable to him. You could, in theory, have an accountable auto allowance where the person is required to turn in receipts, and if those receipts total more than the $600, I don't even know if you'd be required to pay that overage. Maybe Marla does. But if they return in receipts to substantiate the $600, then presumably you'd be able to pay it through accounts payable. Hopefully that's what she meant by that question.
And let me add, Linda, that the amount doesn't matter. Under the Labor Code in California, an employer is required to reimburse an employee for all expenses incurred in furthering the business of the employer. So any expense, and mileage can be done, by tracking your miles, or turning in receipts if you're paying for, maintenance. But, an example Debbie and I were talking about earlier is if I run to the store and pick up snacks for the office at Staples or paper, and at the request of my employer, I'm entitled to be reimbursed for that. And if it goes over $600 or $6,000, that's not taxable.
Okay, good. Thank you. And Kathy has a question too about if it's legally okay to deduct questionable use of a company-paid credit card for business expenses.
Well, that's a good Marla question.
Well, I'm sorry, I didn't hear the question. Is it legally okay to pay what?
Is it, again, and I'm assuming Kathy's saying from the final paycheck, is it legally okay to deduct questionable use of a company-paid credit card for business expenses?
No. No. No deductions.
So no deductions. That final paycheck, I'm sorry, go ahead, Marla.
If you have the employee's permission to deduct for something in writing that day, the date of termination, and you have not coerced that permission, then you can deduct for money owed, but otherwise no deductions. And again, it's the employer's responsibility. Like Linda said, many of our employers are told this. I've not had many do it. I've had a couple. You have to go after them, small claims, or if it's a larger amount, Superior Court.
Got it.
But
okay.
never deduct.
All right, good. Ramika has a question. Does the employer have to pay 1 hour of pay if an employee doesn't start their meal period by the 5th hour?
Yeah, if you pull up the Brinker case, you know, you can pull up the Brinker case, but if you pull up the slides from the Brinker event webinar that we did, we talk a little bit about that. There is a 1 hour meal pay period in California, so if they are unable to take their meal period, you're going to owe them that 1 hour of pay in addition to all of the rest of the wages. Now, there are times when people can't take their, you know, their meal period on time. So, Marla, do you want to jump in on any of the sort of exceptions to that?
Not really. No, they're so limited. It's best to just know that if you have not given the meal period, the opportunity for the meal period by the start of the 5th hour, then yes, the potential penalty is 1 hour of pay. There are exceptions in certain other wage orders, but they're specifically limited. For example, if you're in the mercantile business, you know, that's an area where you've got people jumping up and down all the time. You can have a pre-paid agreement, or pre-written agreement between the employer and the employee that might not happen, and then you wouldn't have that penalty.
Okay. And Julie, let me ask Debbie a question about that. Debbie, your system, is there any way for your system to like be programmed so if somebody doesn't take their meal period, it automatically adds in the penalty, or does an employer need to tell you guys, hey, we owe this person an hour?
Our time and attendance, what it can do is flag the employer if someone didn't take the meal after the 5. They can see it right on their email that someone didn't take that, so they're alerted. And also if someone even didn't clock out at the end of a day, it can do more things like that, but not tell them, you know, not put in a penalty or anything like that. It's just kind of tracking and alerting them.
So what kind of alert do you mean? I don't get it.
Well, let's say they have 50 employees on our time and attendance, and it's over 5 hours, and they see that an employee has not, they don't know, but the system knows because you've asked us to put in these alerts that that person has not clocked out to go on a meal. You would get an email with an alert that Susan has not clocked out. She's now been working 5.5 hours or whatever it is. It's just an alert to help them to then call the manager and say, hey, Susie hasn't used her lunch. And if there's no, you know, like you said, in a retail, I know sometimes they get really busy and slammed and they can't do it. But if it's just a normal situation, also at the end of the day, it'll flag all the employees that didn't clock out, so they know to address that.
When you say an alert, is that like an email that gets generated to somebody, or is that like something that pops up on the payroll person's computer, or what?
Yeah, it would only be to the payroll person responsible for the time clock that would get that alert.
Got it. Okay. Julie, I'm gonna hijack you and ask Debbie another question.
Okay.
I thought it's something that a lot of my clients ask me actually, and that is, should we wait until like January 1st to change payroll companies if we're going to do that, because we don't want to end up with like 2 sets of W-2 for all of our employees?
Oh, that is the greatest question. Yes, if payroll companies just did it once a year, they'd be fiddling their thumbs all year long. So no, we do a balance and audit back to January no matter when a client wants to come to Ovation. And what that means is we are going to take responsibility and liability from going back to January of this year. We are going to provide, if it's, let's say in October, the 4th quarter return, all the year-end returns, and 1 set of W-2s. So we are completely liable and responsible for that, and happy to do that for them because we do that full balance and audit back to January. And then a lot of people think, oh, that's a lot of payroll. Maybe I'll just wait. That's a lot of work for me, or maybe I had a bad conversion with another big company that didn't go well. That's my expertise. I'm very good at going in to their current software. If I'm given the username password, I can pull all the reports we need. Then we send them edits showing that everything's balanced and audited before we run the first payroll for them to review. So they're confident and they know that we are ready to go, and they're going to get one set of W-2s. So they can take away all of that problems that they think they might have if they do an earlier conversion.
Well, and Debbie, along that same line, Jan has a question here about when you're considering outsourcing. So again, this would be for a company that maybe is doing payroll in-house or not. What questions, what types of questions, and I can see how this would certainly work with, trying to switch, outsource payroll vendors too. What types of questions should they be asking these potential providers? So
that's another great question.
Yeah.
Number one, I can tell you, let me give you a story. There's many small little companies in Newport Beach, since I've worked in this area so long, in Fashion Island. There was a small company, we'll just call it ABC, it doesn't really matter, but it was just two people that got together with a software and were doing payroll, and they went into all these surgeons, like highly compensated surgeons, and they all were friends, and they got their friends to join, and they all were doing their payroll. And the problem was that all of a sudden these surgeons, who don't really look at their mail a lot because they're very busy and they're not really into that part of it, they were getting penalty notices from the IRS. Hey, we didn't get your returns, we didn't get the money. So they were calling this company and they said, oh, it was just a little software glitch. We got it to them. Don't worry about it. Everything's fine. Well, pretty soon they started getting levied and taking money from these surgeons' accounts. When they went over, and this one doctor told me this story, went over to their office. Well, number one, they called one day and the phone just was disconnected. Went over, looked in, peered in. Here's papers on the floor, all dark, everyone's gone. So you really have to be careful that you really use a company that is bonded to, have an insurance bond against any penalties, because truly the IRS and ADD doesn't care who you choose for a payroll service. But if they are not paid timely and accurately, if you don't have a payroll company that's going to back that, you will pay your taxes all over again. And a lot of these doctors, unfortunately, one went through a divorce, one went bankrupt. I mean, it just really ruined their lives because they used, the small company that did not pay their taxes. So I would say to be very careful, like we are publicly held so that, our records are open book, that you have a company that is established, that it's not a brand new fly-by-night company, and that they will do that balance and audit back for you if you do come mid, because all of them do not do that and guarantee it. They'll just take what they can and go forward, but if the W-2s are wrong, they'll say, oh, sorry, you're going to have to pay for that to be amended because we didn't do your payroll for the full year. Now, that's a real famous one from another big national company that I can sell against real easy. So, yeah.
Well, and Debbie, along the same lines too, Gail has a question about they're a small company. At what point does it make sense to consider using a payroll company? I mean, it kind of goes with your story a little bit, but is there a threshold? You got 15 employees, that's when you should outsource your payroll, or how do you help clients determine when to use an outsourced payroll service?
Thank you for asking that. Yes, that comes to me quite often because a lot of companies say, I just have one employee, a little admin person. I think we're just going to try to do it ourselves, and as we grow, we may reach back out to you. And then, lo and behold, they call me back in 3 to 4 months and said, I have a nightmare on my hands because I didn't understand all these pitfalls of payroll. We did it incorrectly. I have penalty notice. I'm lost. What am I going to do? So you know what? My answer is one employee. One employee right from the beginning, just do it cleanly, outsource your payroll. I have worked in this industry and mostly with CPA firms is where I get most of my business. And hearing them, they call me and say, Debbie, I have this company with 1-2 employees. Can you help them? Because they asked me to do it as the CPA, and we use you to do our payroll. We don't want to do payroll. It is something that's a liability, and we encourage all our clients, even with 1 employee, to use the service. So my answer would be no company is too small to get on track correctly. From day one, when they hire that employee, we'll make sure they're in compliance and that they do their taxes correctly, because when you outsource, you'll never, ever have a penalty, because we would take care of any penalties if there was one. And keep in mind, the IRS and EDD admit that 50% of their penalties are incorrect. But the problem is the employer has to prove it. This happened to my husband and I. We're employees, but we opened a little corporation, and my husband was kind of taking over this, which I never should have let him. But we started getting penalties that the money was not received, and I knew the money was sent. So they were going to levy and come after us, so we had to hire a CPA, and we spent $800 with the CPA to go through our records and prove to the IRS that truly the money was timely and accurately sent. And they looked and they said, you're right, thank you, sorry, none of them were sorry, thank you. So we ended up paying $800 to prove, because again, the IRS, when they send you a penalty, you have to prove them wrong. So if you don't know what you're doing and you have to hire someone, you're going to pay those fees. Many of my clients show me before they come on that, oh man, I just paid $350 because they said I paid this incorrectly, and we would have gone back and done an audit and reviewed it and let them know, yes, it was incorrect, or no, it wasn't. So they just get out their checkbooks and go, $250, go ahead, take it. I don't know how to fight it. So again, it saves you money to outsource. It's smart. It's something that you don't want to do yourself. Truly, is payroll in-house. It can really turn into a nightmare unless you really have a lot of background and can keep up with all the changes of the laws and rules and deposit periods, on and on. Yeah, it's a lot of changes. It's a moving target.
Well, yeah, and again, with the rules and regulations and everything else you have to keep track of, it's a good thing to look for expertise on the outside, I think. Again, we have a ton of questions left over. Very sorry we didn't get to them. I will be forwarding those questions onto our speaker panel today so they can follow up. And of course, you may follow up as well by just accessing each of their email addresses within the bio slides. I just, on behalf of Linda Duffy with Ethos Human Capital Solutions, Marla Mehrab Robinson with Mehrab Robinson, Jackson, and Clarkson, and Debbie Biscotti of Ovation Payroll Services, I'd like to thank all of you for joining us today. Again, feel free to contact any one of the panelists if you have any questions. And then we're going to switch gears a little for next month, and we're going to talk about social media and recruiting. There are some pitfalls you can fall in as you go to LinkedIn and Twitter to look for your next new hire. And we'll cover not only how to do the best practices on LinkedIn, but then also some of the social media landmines to avoid. Mark your calendars for November 14th at 11 a.m. And there's also a registration link here in your handout, so you can certainly sign up for that right away. We certainly appreciate your time.